Good evening. My name is John Milburn. I'm the course coordinator for Laws 11046, Law and the Environment. It's week 11, and tonight we're covering a few issues. This will be the last substantive night. Next week will be a review night and a night for any questions. And of course, if anyone wants to take me on in a typing test, that'll be your opportunity to do so. Firstly, I'd like to mention a few things about mediation. We have talked about mediation in the context of the Planning and Environment Court rules, and you'll be aware of the concept in general terms. You may have heard of mediation and you may have heard of conciliation. Both are effectively ways that the parties can come together in the hope of discussing issues and coming to a resolution. Both have a person in control of the process. That would either be the mediator or the conciliator, as the case may be. But they're very similar, but there are some differences, and I'd just like to talk about those in general terms. One thing I can say is that whether it's a mediator or a conciliator, that person who is appointed to take that position will not take sides or make decisions, with some exceptions as far as conciliation is concerned. They're not going to tell the people what decisions to make, but particularly in conciliation, they may be in a position to make some suggestions, but certainly they're not there either way to determine who is right or wrong. The proceedings are without prejudice. They're confidential in terms of ensuring that if there are any offers made between the parties, that remains within that confines of the mediation or the conciliation, not to be used in later court proceedings, should the matter fail to settle at that stage. Now, mediation in its pure form is not interventionalist. Now, what I mean by that is that the mediator's role is to facilitate, it's to assist the parties in coming to their own resolution. Conciliators do that as well, but a senior member from QCAT, Peter Stilgo, likes to describe it as, Judge Kingham, formerly of QCAT, and Peter Stilgo, talk about mediation with muscles as being what we can sort of describe conciliation. So conciliation is like mediation, but the conciliator has power to step in and make decisions by way of directions, not final orders, not determine who's right or wrong, but has power to, direct the parties in some meaningful and legal way, but also to provide some suggestions and provide an opinion carefully in terms of what that person thinks the outcome might be. But either way, whether it's a mediation or a conciliation, the person in charge will try to identify from the parties that are in dispute what are the issues, perhaps encourage the parties to develop options to resolve their dispute, consider alternatives, and help the parties to come to an agreement. Now, a conciliator may have special professional expertise, and the conciliator may actually provide some advice, but as I mentioned before, that would be very carefully done. Mediators don't have that role to provide advice. So in a conciliation, it's more directive, it's more advisory than a mediation, and that's probably one of the main differences. So why would someone choose conciliation over mediation? Well, perhaps the parties would benefit from having some additional input and indeed intervention of a third party. Maybe the dispute becomes a bit technical or legal, and the parties are looking for some guidance rather than having to try to resolve it themselves, as is the case in mediation. So in a conciliation, the parties are still in control of the process in terms of determining what the outcome will be, but they might appreciate having someone who has some authority, some experience, some knowledge, who is able to provide some meaningful input and, if necessary, to impose some directions and orders on the parties at the end of the day. So that may be useful, particularly in circumstances where a party is not legally represented. So in the context of environmental law litigation, if you're advising a group of objectors, for example, you might want to talk to them about the relative benefits of mediation or conciliation. And there are a whole lot of different ways that these things can take place. It doesn't have to be in a single room with the parties at one end or one side of the table and the mediator or conciliator at the end of the table. This can be done in a shuttle mode, meaning that the parties are in different rooms and the mediator or conciliator moves between the two, or it can be done by video conferencing means. It can even be done by exchange of letters or telephone in certain circumstances. So in the criminal law context, in case conferencing, as we call it, we'll often do that by emails as well. All right, so what does the mediator or the conciliator do? At the start, they really want to identify the issues. They want to ensure that the parties are aligned in terms of identifying what the issues are to be considered and agreeing on that, and then moving on to consider through joint session what are the relevant facts, what are the understandings of both parties. It's a great way to clarify misunderstandings, and it's also a very good way to create some meaningful communication between the parties. And all the time, of course, the conciliator is trying to assist the parties in generating options for an agreement. So in a mediation or a conciliation, it's available for the parties have the opportunity to come up with their own agreements. Otherwise, if they go to court, the court will impose an agreement on them. And the opportunity in a mediation or conciliation is to come to an agreement which might be essentially not part of the litigation. It might be something which is generated as an option for them. Now, in a conciliation or a mediation, it's very common for a process to continue through where there's an opening from both sides, there's a general discussion, there's perhaps some exchange of ideas and compromises, but then typically there would be a private meeting. And in that private meeting, anything which is said to the mediator or conciliator remains confidential between them, not to be disclosed to the other side. But those private meetings are really good in that it provides the mediator or conciliator with an opportunity to really test the value and worth of a person's case, and perhaps consider some of the weaknesses, and maybe talk about candidly the possible outcomes, and of course talk about the issue of costs and the whole issue of what happens if we don't resolve this. After the joint sessions that normally go back into, after the private sessions normally go back into a joint session. All right, so there can be some real advantages in mediation and conciliation. Specifically, if you're talking about advantages of conciliation, you might say that disputes can be resolved more quickly. Well, that's the same for mediation as well. It may be that if the matter isn't resolved, it has to go to a court or tribunal, or in the case of relevant disputes to the BCCM. So parties can find their own solution, and it's a way of improving communications between those parties which might otherwise not exist. All right, so I know I'm moving very quickly, but you get the idea that mediation, conciliation is now a very substantial part of litigation in planning and environment law, and it's important that you understand the process briefly, understand some of the advantages and disadvantages, and understand briefly the difference between mediation and conciliation. Sometimes conciliation can be mandatory, whereas generally in its pure form, mediation can only be voluntary participation. All right, now as indicated, the conciliator can actually become involved. In a pure sense, mediators don't become involved in the dispute. They remain a little separated from the dispute, and they don't, for example, offer opinions. They don't generate different options that might be available. That's in its pure form. In conciliation, the conciliator will do those sorts of things, and to the extent that the conciliator will do that, well, that's a question of degree. But in general terms, I suppose we could say that conciliators can be more robust about the way in which they help the parties to deal with those issues which are in dispute between them. All right, they can certainly give some idea of the likely outcome as they see it, which is one of the reasons why typically conciliators may have more industry experience or may have some credentials. So, for example, in the jurisdiction that I'm most familiar, which is QCAT, being a member of QCAT, I will often act as the conciliator, and because I'm a member, I have that ability to perhaps speak with a bit more authority. So the same thing applies in the ADR jurisdiction for the Planning and Environment Court. The ADR registrar, in those circumstances, may be able to provide, an opinion which is going to be considered with great respect, one would hope, by the parties because of the specialist area of practice, for example. Okay, so are there any questions about mediation or conciliation, the way it fits into the ADR process, and the advantages and disadvantages? Again, I apologise for moving fairly quickly. All right, let's move on to the next topic, community litigants. Now, throughout the course, we've talked about what's involved in litigation, some of the risks, some of the procedures that need to be followed, and in a general sense, community litigants, submitters or objectors, if you like, people that want to take a stand against a proposed development, for example, do face a number of challenges, and I'll just run through some of them briefly. First, and probably most obvious, is cost and time, but also community litigants, and I'm talking about objectors or submitters here primarily, need to deal with some dynamics that they're probably not used to, such as dealing with a group. It may be that if you've got one objector or submitter, they may have a certain view, but if you've got 20 or 30 different objectors or submitters as a group challenging, it's conceivable that different members of that group have different views. So the group dynamic is an issue as well. Oftentimes, objectors are not legally trained, and sometimes they fail to understand the real importance and the role that experts have to play in litigation. Can I just say that not unreasonably, courts, tribunals will consider the role of the information provided by experts, because the expert opinion must be considered with great respect, and courts and tribunals will do that. So if you're an objector, if you're a submitter, you need to understand that and be prepared to ensure that you have that you have experts that are ready to go. Then, of course, there's the issue of paying the experts. Some other things that objectors and submitters need to be aware of, things like dealing with strict time frames. Now, we've talked about that during the course, the fact that you've got certain time frames, and in planning and environment litigation, they are likely to be strictly monitored by the judge who takes a supervisory role in that regard. In a courtroom context or even a mediation context, submitters have to deal with unfamiliar surroundings, and they need to comply with these practice directions and rules. They need to prepare affidavits in an appropriate and acceptable form. They have to understand protocols in court. So you've got that excellent video that Judge Morzone provided to consider. They have to understand in processes such as mediation and conciliation, and they have to ask the right questions. Now, this really comes back to the issue of planning. Okay, so what sort of questions do submitters or objectors have to ask themselves? Well, I guess the most obvious is, can we win this case? But they have to think about what is it they really want to achieve? What is the end result that they seek? And of course, they need to be realistic about their strengths and weaknesses. And very importantly, think about what is the worst possible outcome that may result in embarking in litigation. So what we call the WATNA, the worst alternative to a negotiated agreement. So think about the best alternatives and the worst alternatives and have that firmly in mind before embarking on litigation or during the mediation or conciliation process as well. So think about what are the consequences of not resolving a matter at mediation, what are the consequences of being unsuccessful at trial. Now, probably the big one, and we talked about this last week, are the costs ramifications and that can be a huge thing. Now, on the way through, talking about the group dynamic, does the group have the authority to agree or settle, or do they provide representatives who do that? And there's this whole thing about internal disagreement between group members. So there's some of the issues that face community litigants, objectors and submitters. Now, we have talked about costs. I'm going to talk about it a bit more. In November 2012, the whole regime about costs in the Planning and Environment Court context was changed. But prior to that time, prior to November 2012, courts were generally most reluctant to award costs against people who were unsuccessful but who did act in good faith and could substantiate their concerns. And that was particularly if they were acting in the public interest. So generally speaking, in those circumstances, even if unsuccessful, courts would not punish, so to speak, the unsuccessful litigant who was challenging on environmental issues. However, since November 2012, there have been these new cost rules created, and that's created much greater risk and I suppose much greater uncertainty for community litigants and all litigants generally, but primarily community litigants. So the general rule previously was that parties pay their own costs, doesn't matter who wins. But as at the 22nd of November 2012, that rule no longer applies, and the new rule is that courts are able to order costs as they see fit. So judges have a general discretion to order costs, and it may be that in those circumstances the court will follow the usual, if you like, uniform civil procedure rule practice of ordering that the loser pay the costs of the successful party. But that's not going to be guaranteed, because even under the new cost regime in the Planning and Environment Court litigation context, courts will consider not just who wins, but all the circumstances and all the factors that might be relevant in coming to that decision. So what are those factors? So the court might think about who won. They might think about, was there some relative success of the losing party in the proceedings? In simple terms, was it a walkover or was it a close thing? They might consider, what was the purpose in bringing the proceedings before a court in the first instance? I mean, if it was vexatious or malicious litigation, then it's far more likely the court will order costs against the unsuccessful party. Also, the court might think about, was the unsuccessful party realistic in its assessment of prospects? Was there a public interest, as well as the interest of the personal rights in the proceedings? And did the party act reasonably, not only in the proceedings, but throughout the whole process? We talked about disclosure earlier, which is the exchange of documents. Were they willing to provide documents to the other side as they were required to do, or were they compelled to do it through a series of orders? I mean, did the unsuccessful party participate in a meaningful way in the ADR process? That's another issue as well. And did the party generally comply with the rules, or were they sanctioned and dragged, and dragged the other party all the way through in sort of, with tactics which included delay, etc. And I guess did the party that was unsuccessful act reasonably and seek appropriate advice? So these are the sorts of things that would come into the consideration of a court in making a decision as to whether to award costs. And last week, you remember, we talked about the difference between party and party costs and solicitor and own client costs. Party and party being set by various scales and generally much lower than what the solicitor actually charges the client, the successful client. And we're not talking small amounts. A costs order could easily exceed $100,000. So if you're advising a party that wants to challenge in the Planning and Environment Court, then make sure that that party is aware of some of the risks potentially in relation to costs. Okay, are there any questions about community litigants, or the issue of costs generally? All right, well, we can move on. Now, you would have seen in the later chapters of Bates issues in relation to compliance and enforcement. There are two main ways that regulators deal with environmental process. The first is in relation to approvals. Should this development application be approved, and if so, should it be approved on conditions? So that's the approval process, and we did a lot of that in the early stages, the Preda-John case, etc. The second is, how do regulators deal with offences? How do they deal with transgressions, which is the Fraser Coast Regional Council against Byrne Brothers scenario? So either way, we might be talking about conditions, and they are conditions that are imposed as part of the approval process. Dealing with a failure to comply with those conditions may result in later breach proceedings, and there are different ways that enforcement action can be taken. For example, it might be through prosecution in criminal matters pursuant to a breach of the Environmental Protection Act provisions. But criminal proceedings, which we discussed last week, are generally a last resort. And just quickly in summary, there is the difference between indictable versus summary, which is essentially matters in the district or Supreme Court, bearing in mind the Planning and Environment Court is really district court, as opposed to summary, which is in the Magistrates Court. And it's a question of the degree of severity of criminality in general terms that will determine whether something is indictable or summary. For example, under the Environmental Protection Act, any transgression or offence which carries a maximum term of 2 years or more would be regarded as indictable. Now, just a brief note in terms of the sentencing process. Apart from imposing terms of imprisonment, courts can obviously impose fines, but under recent changes, there are other things that courts can do in terms of some sort of appropriate order. The courts may, in a criminal law context, the courts may make a public benefit order to restore or enhance the environment. They may make an education order. They may make a monetary benefit order, or they may make a publication and notification order. So these are different things that courts could consider when sentencing. When it comes to the process of sentencing, courts will consider a number of things as well. And these are typically put forward by way of mitigation. That is not a defence. Mitigation is saying, yes, it's a plea of guilty, but please bear in mind these factors. Not a defence, but factors that are relevant. So, for example, if it's a plea of guilty, did the defendant cooperate with authorities? Has the defendant shown genuine remorse? Is there a likelihood of reoffending? And what are the personal circumstances of the defendant? For example, age, health, etc. When it comes to criminal proceedings, there may be a couple of key defences. So if you happen to be advising a person who is faced with the prospect of being prosecuted in a criminal context, you may need to talk to them about the defence of due diligence or the defence of honest and reasonable mistake of fact. Due diligence is essentially saying something happened, but I was doing things appropriately and reasonably. So in the context of due diligence, you may need to look at whether there was compliance with environmental management systems or the completion of an audit, and they might be good grounds for establishing due diligence. Just on that topic of audits, audits can be imposed mandatorily, but they can also be undertaken voluntarily. So if you're advising an environmental group or an industrial group, you might want to raise the issue of an audit as to whether that might be a good thing generally, but also a good thing in the situation where they might be prosecuted as well. So it might be easier to establish a defence of due diligence if you've been through the audit process, if you've complied with environmental management systems as well. Okay, again, I know I'm firing a lot of information at you. Please feel free to ask any questions or follow up with emails, or better still, questions through UCrew. But I am getting close to the end. Apart from issuing criminal proceedings, regulators can take action through civil proceedings or administrative proceedings. And that can be done at the, if you like, the public service level, or it can be done at a ministerial level. So in Queensland, for example, the Minister has an option to make an interim conservation order for the conservation, protection or management of rare or threatened wildlife, critical habitat or protected wildlife, or areas of major interest or protected areas, and that's Section 102 of the Nature Conservation Act of 1992. Other than that, a government agency may issue an enforcement notice or make an enforcement order if it reasonably believes that a person has committed or is committing a development offence. So that's Section 590 of the Sustainable Planning Act. And as you probably have seen, there are a number of provisions in the Sustainable Planning Act which allow for a complainant in a prosecution in relation to a development offence to bring matters before the Magistrates Court. That's Section 597. However, proceedings may also be brought by a person in the Planning and Environment Court, we would have seen that in Byrne Brothers, for an enforcement order or an interim enforcement order pursuant to Section 601 of the SPA. So an enforcement order may be made if the court is satisfied that an offence has been committed or will be committed unless it's restrained, that's Section 604, subsection 1 of the SPA, or make an order requiring an undertaking or cessation of activity. So in that context of seeking an enforcement order through the Planning and Environment Court, as you would have seen, there are a wide range of things that the courts could consider by way of an order imposed against the if you like, the guilty party. A couple of other small points that, well, not so small, but Section 456 enables a person to bring proceedings in the Planning and Environment Court for what we call a declaration. And a declaration is a particular type of order which is where the court declares something to be the case at law. So it's not compelling someone to do something, but it is saying, essentially, in this scenario, this is a statement of what the law is, and the parties can act upon that accordingly. All right, well, we're just about wrapped up for tonight. I do want you to look at merits reviews and judicial reviews. I know we've talked about this a number of times throughout the course, but it's important that you have a look at that and have a look at Chapter 20 of the text. All right, unless there are any questions or comments, I'll stop recording now, and all the very best. Bye.